Solicitor General Tushar Mehta today appeared on behalf of the Secretary of the Governor in the state of Maharashtra and, as requested yesterday by the Supreme Court's three-judge bench, submitted documents to justify the decision of the Governor to revoke Precedence Rule and invite Devendra Fadnavis to form government in the state. Now, he cited two letters primarily, one by Ajit Pawar to the Governor, which said that Ajit Pawar was indeed the leader of the NCP and had signatures of 54 MLAs to support that. Pawar's letter also said that he wished to form government with the BJP in the state because that would lead to a more stable government. The second letter was by Devendra Fadnavis to the Governor, staking claim after having received support from the NCP and through Ajit Pawar. It was also said in that letter that earlier when he was invited, he did not have the numbers, but now with the support of the NCP and 11 independent MLAs, he could form government. There was no reason for the Governor to disbelieve these claims, which is why he acted as he should have and went on to revoke Precedence Rule and invite the BJP in alliance with its allies to form government in the state. Mehta submitted in addition that a judicial review of a governor's decision was not possible and the court could not manage the house because it was constitutionally barred from doing so. The only instance where the court can intervene is if there is horse trading or any substantive illegality that has taken place. In this case, Mehta submitted it had not taken place. Interestingly, Tushar Mehta also said that on the other side, it wasn't just horse trading, but the entire stable had been moved. Senior advocate Mukul Rohatgi then appeared on behalf of Devendra Fadnavis and said that initially he did not have the numbers to form government, which is why Precedence Rule was invoked, and when he received support, he staked claim and the Governor acted appropriately. Now, it was stated by Rohatgi that the constitutional parameters need to be looked at and what is stated in the Constitution in terms of procedure is what needs to be followed. So first, a pro tem speaker needs to be appointed, then MLAs are administered oath by the pro tem speaker, then a speaker is elected and then a floor test is conducted. His submission was that this procedure cannot be flouted and the petitioners seek exactly that, which is for the Supreme Court to act as a speaker and order a floor test immediately. Senior advocate Maninder Singh appeared for Ajit Pawar and claimed that he was the NCP and there was no challenge that he was the head of the party. Now, saying that the original documents are absolutely correct, he stated that there was no case made out and the Governor must be allowed to take his decision. Senior advocate Kapil Sibal then argued that there was a prima facie case made out in this situation because there was malafide involved. He cited the manner in which at 5:17 AM, the Precedence Rule was revoked and Devendra Fadnavis took oath as the Chief Minister of Maharashtra, especially because on the 22nd of November, at 7 PM, there was a press conference by the alliance of the NCP, Congress and Shiv Sena, where it was stated that the next day they would stake claim and Uddhav Thackeray would be the Chief Minister of the state. He said that if the Governor could wait from the 24th of October to the 9th of November, why could he not wait one day and act in such haste? Representing the Shiv Sena, Kapil Sibal also stated that the pre-poll alliance between them and the BJP fell through because the BJP did not fulfill all its promises, and that is why Sena came out of the alliance and it had nothing to do with the Congress or the NCP. Abhishek Manu Singhvi then appeared for the NCP and stated that the signatures that supported Ajit Pawar to be the head of the party was only for that purpose and not to support an alliance with the BJP. He also stated that Pawar had since been removed as the chief of the NCP. Now, controversially, Singhvi said that when someone says that they are the NCP, in this case when they are not, it amounts to perjury. However, Manu Singhvi refused to put this on record through an affidavit and said that he only wanted to shock the conscience of the court. Manu Singhvi in his next argument stated that there have been a number of instances where the court had ordered a floor test within 24 or 48 hours and this was a case that was fit for such an order. A floor test will be conducted in Maharashtra to determine who forms government, but the big question is whether it will be conducted as per the earlier schedule or in the next few days as sought by the petitioners. The Supreme Court, after hearing all the arguments, has reserved its verdict and will deliver the same tomorrow at 10:30 AM. Follow LiveLaw for all developments as and when it happens, with me Neelashish Chaudhary signing off with Srijit for LiveLaw India.